there really ended up being two issues. The state had contended yesterday that Garcia had opened the door to other criminal activity between Mr. Garcia and his co-defendant yesterday. From their opening statement, I did go back and listen to the opening statement. I do not find that they have opened the door to other criminal activity at this point in time. There is certainly discussion about Mr. Rivera's gang affiliation. He does say Mr. Rivera would have the ability or wherewithal to involve other gang members, and it might make common sense that he would do that, but he does not make the statement that Latin Kings only do criminal activity with other Latin Kings. Were that the case, I would let the state, I would agree with the state to open the door, but that's not what is said in the opening statement. Although I wasn't watching it or listening to it for this purpose, there was an issue that I had forgotten that Mr. Sangané did bring up in an opening statement. He very clearly says that he and Mr. Rivera were here in Tallahassee not to do a murder, but to engage in drug dealing. So the objection to, I think it was co-counsel's question about drug dealing, I think that Mr. Sangané has opened that door. There was some dispute whether the witness answered the question or not. I don't think the witness answered the question, but I guess the record will reflect that better than my recollection. But I believe there was a motion for mistrial. I think this would bear on that also, in that it's very clear Garcia has opened the door to discussion of drug dealing. So those were just two observations. I don't intend to go back and undo anything or redo anything, but those are observations from review of the opening statement. Any other issues from the state this morning?
Judge, there is one issue that I think we'd like to address at sidebar with Your Honor.
What's that?
There is one issue that we'd like to address at sidebar with Your Honor.
Correct, Your Honor. It of a somewhat personal nature.
Anything else from the state?
No, Your Honor.
Garcia? McBain, what?
No, Your Honor.
All right, I said we were going to discuss jury instructions a little bit. Who's going to be handling that for the state?
I will, Your Honor.
Okay. You can be seated. Y'all remain seated during this process. I know it's hard to read and stand up, talk at the same time. Mr. Sangané, you handling this for Mr. Garcia?
That is correct, Judge.
And from McBain, who's speaking?
Ms. Kawhi.
Okay. All right. Go through I would assume everybody's got what I sent out to you.
Yes, sir.
Right. Ms. Sangané, Ms. Kawhi, you have it. You can remain seated.
Thank you, Judge.
All right. Okay. The first part of it is fairly standard. Anybody found any issues in the statement of charge, introduction to homicide, justifiable homicide, or excusable homicide?
No. No, Judge. Would you like me to stand when
You can just remain seated. Okay, relax. I know, got you well trained. All right. Ms. Quash, you found anything?
No, Your Honor.
Okay. First degree murder, the only theory that has been presented to the jury was premeditated murder. I think it's all simply a standard instruction. Anybody found any issue there?
No, sir. No, Judge.
No, Your Honor.
Ms. Quast?
No, Your Honor.
Okay. What lessers is Garcia seeking?
None.
What?
No lessers, Judge.
McBanoa?
None.
Say,
We would like the standard lessers, Your Honor.
which you would see as what?
Second degree murder and manslaughter.
Any defense attorneys have any legal cause why I would not give the lessers second degree murder and manslaughter? It would appear they're category 1 lessers. Either side is entitled to request them. Somebody have a legal argument they want to make.
Your Honor, the only argument I make as to Ms. McBanoa is there is zero evidence to support a manslaughter or second degree as it is to my client because she's charged as a principal to first degree murder. So, and manslaughter, for example, is there's no specific intent there, so I don't understand. It would be a clash of legal terms if she's a principal to manslaughter.
Proceed.
And Your Honor, if I may, I believe that they are category 1 lesser included. The government's theory and the evidence that they've produced doesn't qualify for either second degree or manslaughter. I think the factual evidence and the government's case does purport and abide by the jury instructions for first degree murder. So we'll reserve whatever the court is.
But, man, truthfully, there are many cases where I'd love not to give any lesser included, but I think the law is pretty clear that category 1 lesser included, either party or any party can request, and the court's obligated to give them. So I'll overrule the defense objection. I'll instruct on second degree murder and manslaughter. Noting that objection, anybody found an issue with the second degree murder instruction?
No, Judge, not for Mr. Garcia.
No.
You can remain seated, Ms. Claus. Just speak up. I'm sorry, Mr. Evans.
None from the state, Your Honor.
Manslaughter, anybody found an issue on that?
No, Judge, not for Mr. Garcia.
None for Ms. McBanoa.
None from the state.
There's an aggravation of a felony by carrying a firearm. The second degree murder and manslaughter can be reclassified based upon the firearm. The 1020 life provisions only apply to second degree murder. That's why there's a difference as to, one of them says as to second degree murder, manslaughter. One says only as second degree murder. Anybody found any errors or have an objection to that instruction?
Not for Mr. Garcia, Judge.
We object, Your Honor. There is no indication whatsoever that Ms. McBanoa was ever in possession of a firearm.
Right.
None from the state, Your Honor.
So I would probably talk about how we would word that. I think there's the squash is correct, at least at this point. I don't really anticipate a change in that. I would think that what we could do is simply say, if you find that the defendant Garcia committed second degree murder, or if you find the defendant Garcia committed second degree murder in the second paragraph, I think that would be the fix to that. Somebody have a different idea?
Your Honor, I don't know that needs to be done for this reason. In the first paragraph of the instructions you gave us, on the line, I guess it'd be the end of the first line, it says the defendant personally used a firearm. So I think that distinguishes between the allegations against Mr. Garcia versus the allegation against Ms. Banois, that there's no allegation that she personally. So I think the jury would be adequately informed that there has to be.
I don't agree. It's essentially a judgment of acquittal as to any firearm charge with as to Ms. McBanois as to personal use. So it would be improper to instruct the jury in such a way that they could conceivably come back with that if they misunderstood the jury instructions. What about my suggestion, Ms. Kowalski?
Your Honor, I have no objection, and I think that is appropriate.
Mr. Sanganin?
You would, respectfully, Judge, you would put it where in the jury instructions?
On each of the first two paragraphs, it says if you find that the defendant committed second-degree murder, I would simply say if you find that the defendant Garcia committed second-degree murder.
Or manslaughter. Okay. That's fine, Judge.
I mean, we could set it all out again, its full name and all that if you want, but it doesn't seem necessary.
That's fine.
All right, so that's what I'll do. And I'm not granting of a judgment of acquittal at this point. I'm kind of assuming where we stand at the end of the case, but anyway. Principles, it's a little confusing on the facts of our case as to principle instruction as to which one should be used or whether should be some combination of that. What's the state's position?
State's position is that both of them should be read, Your Honor. Maybe some modifications. It's just like you would do, for instance, on if we had a felony murder, when you were explaining first-degree murder, it may be proved two ways, and it may be a situation here where something to the effect that principle can be done two ways. One of which the standard principle instruction. The second would be the when active participant hired by the defendant.
Garcia.
Judge, I believe the general instruction relates to Mr. Garcia. I think that I don't think the second principle portion applies to Mr. Garcia. I believe that Mr. Rivera's testimony was that Ms. Adelson, the lady he keeps referring to over and over again, was the person that was going to pay him. And there's no direct testimony that my client actually paid him.
Well, it could be construed that Mr. Garcia was paying Mr. Rivera, although Mr. Rivera was aware had a belief where the money was ultimately coming from. Anyway, what's McBano's position?
Your Honor, I would object to the principles when active participant hired by defendant. I believe the standard principle instruction sufficiently covers the allegations in the case. Subsection 2 specifically says that the defendant did some act or said some word. The jury doesn't need a specific instruction that specifically says paid or promised. I feel like it's giving almost like an improper bolstering to the state's theory. They can argue in closing argument that if you find that she paid for it, that is an act. I mean, to then have that and then another instruction separating paid for, if the jury instruction as it stands is sufficient enough for the jury.
Well, no. I didn't make this up. This is the standard instruction. What's that?
I apologize, Judge. I just think that having both of them is not necessary and just the one would suffice. I think it would confuse the jury to have both.
Mr. Evans?
I don't think it would confuse the jury, and just because somebody's a subcontractor, to address Mr. Garcia's argument that it doesn't take it out of being a principal hired by a defendant. So I think the evidence supports giving both instructions, and we would be requesting both instructions. I think they're both a fair and accurate statement of the law, and that's what the state is entitled to.
Well, I'll reserve on that. We don't have to resolve everything today. I'm gonna rough something out and I'll send it to you. We can make a final determination at a later date. Is the defense seeking the independent act instructions?
Judge, at this point, we haven't made a determination. I'd like to see the rest of the government's case.
Okay, well, that's fair. Generally, what I find is that if the state seeks principal, the defense seeks independent act. That's why I included it. But if y'all don't want it, I'm sure the state will be happy not to include it. But y'all can make a final determination on that later. All right, the conspiracy. What's the defense position of lessers? Garcia's position of lessers on the conspiracy and solicitation.
Not requesting either one.
McBanaway?
Relying on the case law you provided, Judge, we're not asking for it.
Okay. Assume the state's okay with that.
Yes, Your Honor.
I highlighted the part that is an affirmative defense, so just wait to see what evidence develops over the course of the proceedings. So that's the only reason that's highlighted, because it's an affirmative defense. As to the instruction itself, anybody found any errors or have objection?
None to the instruction itself. I don't believe the evidence supports it at this time.
Say what?
I don't believe there's sufficient evidence to support it at this time, but as to the form of instruction, I think what you're asking for, I don't see any error in how it states the law.
Garcia?
No objection.
Quad?
No objection.
All right. As to the solicitation, it's the same thing I've highlighted. Make a determination at the end of the case whether there's evidence of a affirmative defense. But as to the instruction itself, anybody have objection?
No, Your Honor.
No, Judge.
No, Your Honor.
Those are the instructions on the charge itself. Is anybody aware of any others they're seeking?
Not at this time, Judge.
No, sir.
No, Your Honor.
What about is from some of the conversation, I wondered whether the state was going to seek a voluntary intoxication instruction or not.
Given an opening statement, Your Honor, we probably would. That probably is a good idea to go ahead and do that, and we would request it.
Well, I'll add it in, and we can have discussion about it later point. All right? All right, so that gets us a little closer. So we'll give you till 9 o'clock, take a break.
Thank you.
Hey.
Yeah, hopefully they decide to.